As UN prosecutor, I'm dealing with the so-called remaining functions of the two United Nations ad hoc tribunals, the one for the former Yugoslavia and the one for Rwanda. So we are having our last trials in relation to the Yugoslav tribunal, with our last judgment coming out next week. Stanisic Sematovic, to intelligence responsible from Belgrade, who had in first instance been convicted for aiding and abetting war crimes committed in Bosnia-Herzegovina. And on the Yugoslav side, we are still very much supporting the domestic judiciary with hundreds of requests for assistance we are still receiving, as there are many hundreds of cases still ongoing in Serbia, Croatia, Bosnia, Montenegro. And on the other side, in relation to the Rwanda tribunal, well, our main remaining function is the hunt for the remaining fugitives. We have been able to close 4 cases over the last 2 years. Currently, the main case ongoing is the Kabuga case. He was arrested 2.5 years ago, but we still have 4 fugitives at large, individuals suspected of having played a major role in the genocide against the Tutsi in Rwanda. Yeah, definitely. I mean, there are a number of challenges. We speak about individuals who somehow disappeared 20 years ago, hiding, we don't know where in the world. And I have definitely, when I took over responsibility for the tracking team, I have replaced a number of investigators by analysts, in particular experts in open source analysis. So open source analysis has been, I think, one of the major tools we have used to locate and arrest some of the remaining fugitives, by looking at the background, by looking at persons of interest, by looking at family members, by looking at movements. So definitely it is today an important tool. There are still many challenges remaining. All our fugitives have up to 15 different identities. Very often they've obtained via corruption fake identities, which in fact are fake names, but on real passports, which have been obtained by the competent authorities based on corruption. So there are a number of remaining challenges because those are somehow cold cases. Open source analysis today probably is much more used for lead purposes than for evidence gathering. And this is one of those important challenges we are having in the future, and where we will see how much this information available of internet can or cannot be used in a court of law, domestically or international level. No, definitely. Of course, I cannot go into details about our investigative strategies, but it is obvious that open source analysis has been extremely important in a number of areas. For example, when you want to know when a fugitive who fled Rwanda to the DRC, to know when perhaps he left the DRC, you can look at political situation, when certain groups were fighting there or were leaving the country. So you can contextualize historically your fugitive much better by looking at open sources about developments of conflicts. And you look at persons of interest, those who were clear. If you're looking for a military leader, you are also looking at open sources to see where are his former comrades, where are they living? Is he still in contact with them? So you are looking at profiles of individuals at internet, and by somehow starting with a larger net of persons of interest, you get more and more focus to the person you are looking for. And people are easily posting pictures of family events, and very often fugitives at the end of their career can only rely on a very limited number of persons, which are close associates or family members. So you learn via looking at profiles on internet, you really learn how to reduce your larger net of persons of interest to a very focused one. And then entering, of course, in the final phase is then more an investigative phase, where you start taking statements, doing interviews, in order really to be successful. Well, I don't think that there are many other options or choices. You know, if you look at the Yugoslav Tribunal, right, set up in '94, the evidence we used was satellite imagery. We have done very often more traditional investigations, a lot of forensic research, and very much on document collection basis. I would say very much traditional investigations.
Right.
Other tribunals have quite heavily relied on NGO report, NGO support, which also represents a number of challenges in relation to the accuracy of the information received. And this is obviously the big challenge in relation to open source material. I mean, we have seen it in our cases ourselves. Once internet really became very, very present, we have seen pictures from the Yugoslav conflict suddenly being related to conflicts in other parts of the world. So as we discussed today, manipulation is easy. Artificial intelligence can all be helped to manipulate evidence. So it is really a challenge to bring up the quality of this open source material to a level that in the mind of a judge there's no reasonable doubt left about the correctness of the information provided. I think we are getting there. We have to go there, but I think still a lot is needed to have kind of joint protocols in relation to the collection of this information, similar approaches to not only the collection but also the analysis, and to have really standards determined by the international community, but certainly at a certain moment standards determined by tribunals to say from which threshold on can it be considered as evidence or not. Now, to imagine that there would be a domestic or an international trial which would only rely on open source material or this kind of analysis, I think it's still a long way to go. But for lead purposes, it is definitely very important. To corroborate information collected via traditional means is extremely important. I mean, if we speak about international armed conflict, it is basically traditionally a conflict between two countries, and most often armies between the two countries. It is much more complex to fulfill the requirements of a non-international armed conflict. You know, if you have organized crime groups committing crimes, if you have an important number of murder cases, we are not yet in the international maritime law. This is domestic crimes which have to be addressed by the national legislation. In order for the international maritime law to come in and the Geneva Conventions to come in terms of genocide, war crimes, crimes against humanity, you need to fulfill the criteria of an internal armed conflict, which means that you need a certain intensity of the conflict, and you need a kind of organizational structure behind the parties. So there we speak about a conflict between the state and an organized armed group, or between armed groups within a country. Now, in relation to the individual crimes, of course, the investigations are very, very similar. Now, the second part of your question was, what is the difference between investigations during a conflict and during peacetime? Well, there, obviously, the major differences is access to the crime scenes, right? If a conflict is still ongoing, it's extremely difficult to collect evidence on the ground. It's very difficult to get in. If the conflict is ongoing, many of the witnesses you are looking for became refugees and are in third countries. You cannot go to crime scenes to really collect any material evidence. So it is, of course, much more challenging to investigate when a conflict is ongoing. I mean, investigation in peacetime, I guess you mean once the conflict is over and there is a peace situation. Well, of course, it very much depends who is then in charge of the country which is back in peace, right? If still those forces who allegedly had a major involvement in the commission of crimes, then obviously you have also a problem, because those governments or politicians who allegedly were involved in committing massive crimes, if they stay in government, their readiness and willingness to cooperate with you will be very limited. You know, when you go to law school, you learn justice delayed is justice denied. You know, you have to come in very, very quickly to be meaningful. Once you work in the international field, you have to learn that time is a very important factor. And that someone who is very powerful today, where it's difficult to start any meaningful investigation, well, the situation can change. So you must sometimes wait for years in order to prosecute this individual. Now, for the survivors and the victims, it is extremely important that their suffering, the crimes they suffered, is recognized. If it's 5 years, 10 years, or 20 years after the conflict, it will still be extremely important. I mentioned that we have next week, or in 2 weeks, our last judgment in The Hague. Well, a number of victims announced their arrival for crimes committed 25 years ago, because it really remains extremely meaningful for them to see those who are responsible for their suffering are, at the end of the day, prosecuted and hopefully convicted in a few weeks' time. And this is obviously challenging and important for every part of the world. And you mentioned Sudan, of course. It will be important that there is accountability for violations of Geneva Conventions and convictions and prosecutions for crimes committed. The challenge will be who will be responsible to conduct which kind of investigations, because as we discussed today, there's one thing doing information collection, analysis, and most often it is done for advocacy purposes. But at the end of the day, in addition to, and I will not diminishing the importance of advocacy, but at the end of the day, it's about accountability, to have really meaningful long-term impact, and also to look into reparations. You really must be able to bring those persons to court, and there, of course, in Sudan and other places, it remains extremely challenging. You know, traditionally, if you look 100 years back, those who were the worst, the most brutal parties to the conflict were sitting around the table, signing a peace agreement, and of course, amnesty for the crimes committed was the rule. So accountability has really very often historically been the last point of importance. What we have definitely seen since Nuremberg, but also definitely with the ad hoc tribunals and now with the ICC, is that there is no amnesty anymore, that there are mechanisms in place which unfortunately are not yet universal, but which make sure that those who are committing these crimes are prosecuted. You know, very often when I'm speaking with students, I would ask them the question, so if by giving amnesty to one of the main perpetrators in whatever country currently, giving amnesty to him would mean the end of the conflict and saving lives, would you give impunity to this individual? And I'm surprised that very often up to 50% of people are saying, well, if the price to save life is to give impunity for the crimes committed. And my answer is always to say, you see, this would be the worst signal you can give. Because if you give any chance to a perpetrator of mass atrocity that he can get away with it by concluding whatever kind of agreement, this would be the worst signal. It would be the total opposite of any deterrence, and should absolutely not be possible anymore in our society today.